that welcome and hello to those who are joining the fifth edition of the Conference on International Coordination for Secure Transactions Reform, which is being held, fortunately, live with many people in the room in Rome, in UNIDROIT's headquarters. It is great to be able to have it back as it used to be in the first three editions. I'm also happy to say that we've taken the conference to the next level. We already did last year in Vienna remotely, and we are now consolidating the institutionalization of the conference. It started as a meeting, more of an academic and public service meeting, and it slowly gained momentum and became a staple platform, which is what we were aiming for. So I'm very happy that this is actually being consolidated live here in Rome. We believe that, and I speak for UNIDROIT here, that the idea and the platform is not only very good, but potentially can reach out beyond secure transactions as well, because it's generally about coordination, and coordination is needed in many areas of the law, not only in secure transactions. But we can take this as a pilot project, and then maybe if things go well, take it beyond. For this conference, we have many of the usual suspects, which I would like to call friends after so many years. Some of them coming from far, and we have a number of new organizations which are joining as well. We have several international financial institutions, global and regional. We have APEC as an institution composed of countries. We have NGOs. We have a very nice lineup for discussion these 2 days. This brief first introductory panel is going to be mostly not only remotely delivered, but also in video. So I'll give the floor first, or I'll play the video first of Secretary of UNCITRAL, Joubin-Bret.
Good morning, good afternoon, and good evening to you all joining us here for this meeting of our partnership and coordination on secure transaction reform. Dear colleagues from our partner organizations, from UNIDROIT, our host, from the World Bank, from the Organization of American States and the National Law Center, as well as those joining us from different parts of the world. It's my great pleasure to welcome you, although virtually, to this fifth conference on international coordination of secure transactions reform. The last time we met in person was in Cartagena in Colombia, which now seems like ages ago, because since then there has been the pandemic and the Zoom screens. I would really have loved to join you all in Rome, especially Rome, but it's not possible. But my colleague Jay will be with you, and my colleagues Angelo and Monica will be joining in as well, so UNCITRAL will be there en force. As in the previous 4 conferences, this event will give us the opportunity to take stock of recent developments in secure transactions reforms, especially from the point of view of implementation and practice, in providing technical assistance to legislative reform, operation of the registry, and building the capacity of relevant stakeholders. Not so much from the perspective of legislative developments, because this is, of course, in the hands of our respective member states, although we have a way in and among secretariats to stay in touch and to coordinate amongst ourselves, and this is what we are doing today. In this regard, I think it is meaningful to recall 2 resolutions adopted by the United Nations General Assembly. In December 2016, in taking note of the UNCITRAL model law on secure transactions, the General Assembly recognized that an efficient secure transactions regime was likely to increase access to affordable secured credit and promote economic growth, sustainable development, and financial inclusion. It also recognized that the harmonization of secure transaction regimes was likely to increase the availability of secured credit across national borders and facilitate the development of international trade. It further recognized that secure transactions law reform could not be effectively implemented without the establishment of an efficient, publicly available security rights registry. And lastly, as it was noted that the model law will contribute to greater legal certainty for the benefit of all states, particularly developing states and countries with economies in transition. These same areas and these same ideas bring us together for the next 2 days to further discuss what has happened in the past few months and what will happen in the future months and years in the area of secure transactions reform. Let me also remind you, and that is my second reference to the United Nations General Assembly, that UNCITRAL was born in 1966 with coordination in its very DNA. In the resolution establishing UNCITRAL, the General Assembly mandated the Commission to further the progressive harmonization and unification of international trade law by coordinating, and here I quote, the work of organizations active in this field and encouraging cooperation among them, and by promoting wider participation in existing international conventions and wider acceptance of existing model laws. And I close my quote. What you will be discussing today and tomorrow is exactly what is expected of UNCITRAL, what was expected 56 years ago, and we're continuing to realize to the date. This is one of the reasons why UNCITRAL took this initiative to formalize the joint network last year, despite the difficult COVID circumstances as we were chairing the executive committee. We were not able to have an in-person launch last year, and we're therefore particularly thankful to our friends and colleagues from UNIDROIT, who are chairing the executive committee this year, for getting us together for what I would say is the proper way to launch a cooperation network. Now, during the next 2 days, let us hear from the relevant stakeholders and really take stock of the wide range of reform initiatives in different parts of the world. As many of you know, successful reforms rely on many different actors at the international, regional, and local level, and on their successful coordination. Let us examine the various facets of coordination, and let's make sure that this joint network for the coordination and supporting secure transactions reform lives up to the task that we gave ourselves in ensuring sound and efficient coordination when providing technical assistance and capacity building. I wish you all very constructive discussions, and I hope to see you all in person on the next iteration of the meeting of this coordination group. Thank you.
Well, thank you, Anna, and apologies for the technical problems at the beginning, which have nothing to do with coordination. So next, I'm going to ask to speak live, but remotely, Hans Koning from the IFC.
Thank you very much. Dear participants, speakers, and moderators, happy to be talking to you at this 5th conference on international coordination of secured transactions reform. My name is Hans Koning, and I'm Global Chief Digital Finance Officer at the International Finance Corporation, or IFC. Unfortunately, I cannot be with you in Rome today, as I am in Jakarta in Indonesia this week, meeting with digital banks and embedded finance providers that have so many opportunities in this vast archipelago with 280 million inhabitants, living on more than 17,000 islands. This country extends over 5,000 kilometers from east to west, which is a flight time of 7 hours. As you know, IFC is a member of the World Bank Group and is the largest global development institution focused on the private sector in emerging markets. We work in more than 100 countries, using our capital, expertise, and influence to create markets and opportunities in developing countries. In fiscal year 2022, IFC committed a record $32.8 billion to private companies and financial institutions in developing countries, leveraging the power of the private sector to end extreme poverty and boost shared prosperity as economies grapple with the impacts of the COVID-19 pandemic. And credit infrastructure plays a very important role in promoting financial inclusion and leveraging these digital finance solutions. So on behalf of the World Bank Group and IFC, it is my great pleasure to extend a warm welcome to all of you at this important conference. I would firstly like to acknowledge and thank our host institution and partner, Ignacio Tirado, Secretary General of UNIDROIT, as well as our long-time colleagues and development partners from UNCITRAL, ADB, EBRD, OAS, NatLaw, APEC, and all other speakers and participants representing the various institutions, academia, and NGOs. As most of you will certainly know, in the developing world, 2.5 billion adults don't have a bank account and 200 million businesses lack access to credit. The World Bank Group works on developing the enabling environment through our financial sector policy advisory work to our government clients, as well as providing firm-level advisory to financial market players to provide much-needed financial solutions for millions of individuals and micro, small, and medium enterprises through financial inclusion reforms. Our Credit Infrastructure Practice Group provides the necessary advisory services to our government clients and builds capacity within the private sector at the sectoral and firm level on credit infrastructure and asset-based lending solutions. Therefore, we strongly believe in the need for collaboration and coordination with international organizations and our many development partners, some of which are represented at this event here today, to maximize the development impact on the ground in trying to address the access to finance challenges faced by many MSMEs and women entrepreneurs. The international legal instruments, conventions, and model laws are key tools to support the creation of national-level legal and institutional enabling environments like secured transactions reform. We see the role we play as development partners in international forums and working groups like this, in partnership with international organizations like UNCITRAL, UNIDROIT, INSOL, G20 SME Working Group, APEC, and others, as a critical element to ensuring policy formulation, promotion, and implementation of modern secured lending regimes. These continue to evolve and need to keep pace with the current commercial activity taking place globally. These tools are critical to the development of the financial markets and improving access to finance for the MSME sector in the developing economies in which we work. I wish you all lively and fruitful deliberations during these 2 days, and I will stop here. Thank you.
Thank you very much, Hans. We now move on to another video, this time from Dante Negro, head of legal at the Organization of American States.
On behalf of the Department of International Law of the Secretariat for Legal Affairs of the Organization of American States, I am delighted to attend the opening of this 5th conference. As this is the first conference since the official launch last December of the Joint Network for Coordination and Supporting Secure Transactions Reforms, I would like to begin by expressing our sincere appreciation and support for this initiative, in particular to the other institutions on the Executive Committee, UNIDROIT, UNCITRAL, the World Bank, and the Kolchowski National Law Center, and also to UNIDROIT for hosting this conference. The OAS Legal Secretariat has participated since the beginning in 2017 at each of the previous 4 conferences, and we are delighted to see progress that has been made thus far. The initiative for this joint network arose out of the recognition that multiple reform efforts are frequently contemporaneous and sometimes duplicated, and that these efforts could be better managed to maximize resources and achieve greater harmonization at the regional and international levels. This collaborative approach is very much in keeping with our department's mandate from OAS member states, namely to promote private international law and to do so in collaboration with other international and regional organizations involved in this field. And secure transactions reforms is one of the topics specifically identified because of its importance to equitable access to credit and economic development. The OAS has been actively engaged in promoting secure transactions reforms in the Americas for over 20 years. Under the auspices of the Inter-American Specialized Conferences on Private International Law, the Model Inter-American Law on Secure Transactions was approved in 2002, followed by the Model Registry Regulations in 2009. In the years since then, our department has worked with local counterparts in a number of OAS member states on a variety of capacity building activities within the framework of the OAS Secure Transactions Project, together with other organizations represented today. Activities that have been tailored to suit the specific needs of each state in its own legislative reform process. During the course of that work, it became evident that the best way to support states at different stages of reform would be to create a space for effective dialogue with international experts in these technical subjects and for an exchange of experiences with representatives of other countries. Many of these exchanges, we believe, have led to lasting collaborative relationships that serve to foster joint work for the development of a modern and regionally integrated secure transactions regime. Lessons learned during the reform process by several states across our region have been captured in a recent publication which is available on our website about the model law and its implementation. Reviewing the extensive agenda for this fifth conference, we are pleased to note that in addition to a variety of topics on coordination, panels will also consider initiatives to improve access to credit in the agricultural sector and to support financial inclusion, two topics that have been of particular focus in the recent work of the Inter-American Juridical Committee. The OAS Department of International Law continues to strive to fulfill its mandate and objective of promoting secure transactions reforms in the Americas. And towards this end, we look forward to this conference and other ongoing activities aimed at strengthening international and regional collaboration through our joint network for coordination and support of secure transactions reforms. Thank you very much.
Thank you very much, Dante. And the last intervention, also video, is going to be by Ignacio de Leon from the National Law Center.
Good morning, good afternoon, good evening, everyone. Welcome to the 5th International Coordination Meeting of Secure Transaction Reforms. My name is Ignacio de Leon. I'm CEO of the Kosovo National Law Center. I have been asked to give you some introductory remarks for this event. The Kosovo National Law Center, as many of you probably know, has been a very active participant in the promotion of legal reforms worldwide for over 25 years. We have spearheaded legal reforms in several areas involving secure transactions worldwide, including the creation of legal registries of movable assets, development of factoring laws, promoting discussions around the world over these topics. Now, with the emergence of the digital economy, there are new challenges that need to be addressed, and we have taken a very strong interest into the discussions of this group for the creation of the working agenda and future steps in the promotion of these reforms involving secure transactions at a regional level in specific industries like agriculture, and creating the necessary conditions for financial inclusion, especially in developing economies. Let me take this opportunity as well to congratulate the excellent work carried out by the executive board of the joint network represented by the institutions participating in this event. For us as well, has been a privilege to be participating in these discussions so far, and we look forward continuing our involvement in future years. So without anything else, let me just say that I wish you very good luck in your discussions and look forward to the conclusions of this event. Thank you very much.
We now move on to the first panel entitled Coordination in the Legislative Development of Secure Transaction Instruments, an Overview. And this is what we purport to do here. So the idea is to provide not only an overview which serves as the layout for the rest of the conference, but also provide some information as to where the three sisters stand and where they're headed for in terms of secure transactions reform. I'd like to say again that the main part of this conference on coordination of secure transactions is the coordination part rather than the secure transactions part, and that is why that important part of the conference explains the interest in the presence and active participation of important institutions, very important for us, such as the Hague Conference, who might not be doing a lot of security transactions work now, but who are essential in terms of coordination and cooperation with us. So the way this is going to play out now is I'm going first to give the floor to Angelo Estrella Faria, who's going to speak on behalf of UNCITRAL remotely from Vienna, I believe. And then the floor will be given to Escolar from the Hague Conference. And then I will finalize myself with UNIDROIT. So, Angelo, the floor is yours.
Thank you. Thank you very much, Ignacio. And I trust that you can, I hope at least that you can hear me well.
We can in the room, that's for sure. Excellent. It would be reassuring to get a text from some saying that those remotely can also hear.
Okay, excellent. Very good. Very good.
Yes, okay, they can.
Yes. Well, these things happen to confirm to all of us that we should all be happy that the pandemic is over and that one day we'll all only be meeting in person. Now, thank you very much for the invitation, Ignacio. Thank you for convening this conference and hosting it. And like Anna, I would have liked to be in Rome myself and join you all. But it happens that I have 3 different meetings going on between today and tomorrow, and I simply couldn't be in Rome and not also attend the other 2. This is also very timely panel that we have to discuss our cooperation. And I see that also in the program that you have opportunity to more concretely talk about the coordination and cooperation as regards the ongoing projects and the existing framework. So in the time that I have in this panel, and I assume that would be at the most 15 minutes, I would like to talk about the nature of the cooperation I've had and the projects that we currently are carrying out in a more general terms. I'd like to begin by saying that the history of cooperation between the 3 organizations is long in various areas, and it has been particularly close in secure transactions, as you all know, by the fact that we have been assigned by our member states bits and pieces of this large area of the law over the years. Cooperation between UNCITRAL and UNIDROIT has been very effective and also very respectful of each other's mandates. Also during the preparation of the model law on the legislative guide on secure transactions and the model law on secure transactions, and also the subsequent practice guide. And this, I think, was also due to a very large extent to the division of labor, so to speak, that existed at that time, with UNIDROIT focusing on asset-based financing, to think of older instruments such as the factoring and the leasing conventions, but also then the more recent suit of the Cape Town family instruments, and then even later on, the Geneva Conventions on Intermediate Securities that, as you know, contains a chapter on secure transactions. And that at the same time, UNCITRAL then had received a mandate for working develop a more comprehensive and ambitious regime through the legislative guide and the model law that would not be asset specific, but would, to a very large extent, be also from the general perspective, also the entrance door for advocating registry systems for secure transactions. But not only from the point of view of the mandate, I would say that even from a greater extent, the coordination was assured by the fact that the participants in both organizations were aware of each other's work and sometimes or even participating both of them at the same time. Now, coordination between UNCITRAL and the Hague Conference was also needed during the preparation of the legislative guide and the model law, but already in the era of secure transactions started with the cooperation during the drafting of the assignment of receivables convention that also contains rules of applicable law, and those rules were developed by a joint expert groups appointed by both organizations. Now, we also have two projects already underway that deal with asset-specific security interests underway mainly at UNIDROIT that are also examples of excellent cooperation. And here I mean the model law on factoring and the UNCITRAL UNIDROIT model law on warehouse receipts. As you know, the model law on factoring was at the beginning, I would say at the very initial stages, object of some doubts on the part of UNCITRAL, because we had some doubts as to whether there was a need for an asset-specific regime after we had adopted the model law that advocated for such a broad security rights regime. But we're soon satisfied that the asset-specific nature of that project would not interfere with any existing instruments of both organizations. And then as the work evolved, it was clear that the registry system that the model law proposes would not lead to a system of hidden liens that would be inconsistent with the model law on secured transactions. So that also allowed us very soon to participate fully in this work. My colleague Jason Lee is present in the room, and he can refer to that when in his next panel when he talks about the consistency between existing projects and the existing international framework. But we're also confident the experts involved in the drafting of the factoring model law will do the best to avoid any conflict. So again, it's an example of a situation that has worked very well in terms of cooperation. Warehouse Receipts 2 is a project that is going well and involves experts that are familiar with both existing UNIDROIT and UNCITRAL texts in the era of secure transactions and the overall work program of both organizations. And these experts have been paying attention to ensure consistency with existing instruments of both organizations. We'll certainly be listening more about that tomorrow in the panel dedicated to secure transactions in agricultural finance. And even if the project of warehouse receipts presents its own challenges because of the technical difficulties of the law of negotiable instruments and the fact that we still have persisting gaps between common law and civil law in this area, which are exacerbated, by the way, by the fact that the UN standard on this area, the 1988 Bills and Notes Convention, has never entered into force. So we cannot refer to it as an authoritative international standard. But there is an overall concern of ensuring consistency with other instruments, with the model law on secure transactions, and even if there is no international standard on negotiable instruments, that at least the principles that presided over the drafting of the model law would be reflected in this area. Where we would have to be more careful and more also sometimes creative in coordination are areas where this sharp divide between asset-specific and generic secure transactions law, and even where the divide between secure transactions law and other areas of the law is not so obvious. And here I mentioned first digital assets in private law. That's a project that currently under development as at UNIDROIT, as you know. And here the difficulty, so to speak, would be on the one hand to have absolute clarity as to the scope and the type of objects that we want to cover with a special regime for secure transactions, so as to avoid the impression that whatever specific rules we develop for them would in a way call into question established rules that have applied already in other areas. To be more specific, we have had for negotiable instruments so far, and this is a discussion that we've had currently in the working group on warehouse receipts, this dichotomy between purely paper-based transactions and electronic transactions. With the UNCITRAL model law on electronic transferable records that proposes a general framework for establishing the functional equivalence between legal notions applied to paper-based transactions and their electronic equivalents. And that's basically apart from the legal recognition of the electronic record as such, the equivalent in electronic environment to possession as a fundamental concept used in traditional negotiable instruments law. The difficulty with the digital assets is that here we're talking about a category of assets for which perhaps some of the old notions of property derived from property law cannot be applied straightforward, and there is some desire to develop from a substantive law point of view adequate concepts for dealing with interests in digital assets. And here we see already in draft Article 12 of the UCC the introduction of this notion of an adapted notion of control that is specific for digital assets, so as not to refer to proprietary interests and other interests that and other concepts that we traditionally use with regard to tangible assets. The problem here is that within the UCC itself, in Article 7, we refer to control as the equivalent of possession only for the purpose of establishing the functional equivalence between the paper negotiable instrument and electronic negotiable instrument. The danger if a project on digital assets, if the scope is not 100% clear, is that one may from that conclude that the notion of control as has been used so far for the electronic equivalence between paper-based transactions and electronic transactions is no longer valid for that purpose. And here, what is happening on digital assets is that we're developing a different notion of control that would encompass not only the form of the issuance of the instrument, but also be a new reconceptualization of notions of property law that have applied to other assets before. So this is one area where I have to, as I said, it's not just a question of defining areas of boundaries between different types of projects, but consider to what extent concepts that seem to become necessary for dealing with particular legal situations would not lead to people to the premature conclusion that a similar concept that I use in different contexts is no longer valid. Another area that I would say that we that would also require from all of us particular attention to avoid any sort of undesired interference is the area of enforcement. I mean, as we know, we already have sets of recommendation principles for enforcement of security interests in the UNCITRAL legislative guide on secure transactions and the model law. But also in that process also was not within UNCITRAL always an easy process. Those rules and principles had to be developed in full awareness of the limitations to the enforcement of secure transaction rights in an insolvency context and the extent to which they would not be subject to the overall insolvency context. And here again is a question of scope and to what extent best practice on enforcement can or should deal also with the enforcement in an insolvency context. To some extent, it's a work that can be very useful in terms of providing a set of tools that could also be available in an insolvency context, if been understood, however, that whatever limitations that would apply have to be observed. We currently don't have a project that would by itself affect secure transactions as such. As you know, since Working Group 6 completed the work on the practice guide, afterward it was tasked with developing a draft convention on judicial sale of ships, which doesn't do a security interest as such, but only with the recognition of a clean title acquired in a judicial sale. So that is not a project that involved not even an tangent security interest. We will, however, be considering soon a project on negotiable multimodal transport documents that is intended to confer upon these documents a document of title function outside the maritime sector where this is traditional. And here, yes, there will be a component of secure transactions that would have to look at, and hopefully by then would have been also illuminated by the conclusion of the work on warehouse receipts, about which we're going to be listening a little bit more in the future. So, I mean, all these remarks are simply to say that we're happy to see how fruitful and effective our cooperation has been, but also to remind us all that this is not just a question of mandate and clear distinctions of the fields of application of different instruments, but one where we have to actively always consider the overall picture of instruments developed concretely in the area of secure transaction, but also in adjacent areas of the law to make sure that whatever we produce is not going to be inconsistent. And I'll conclude by saying that we're also looking forward to the continued input of the Hague Conference in the work that we'll be doing, that we are doing already on applicable law in insolvency. Also, that work, to the extent that it concerns also the creation and effectiveness of security interests created abroad, as opposed to those that created under the law, the Lex Fori Concursus, is one that also would touch upon secure transactions law, and one where all the organizations would have an input to offer. So with that, those are my remarks for the moment. Ignacio, I thank you very much. I hand over the floor back to you, and I'm happy to discuss and after the other presenters have concluded. Thank you.
Thank you very much, Angelo, for this comprehensive intervention. We might have time for discussion later. But now I'll hand over the floor to Jerry.
Thank you very much, Ignacio. And this is the first time that the Hague Conference on Private International Law is participating in this conference. We're obviously very late to the party, but it's very nice to be here with all of you today. Perhaps a bit of a background while we pull my slides up so you don't have to look at me, you look at the slides instead, much better looking. One of the interesting things is, in preparing for this conference, my team at the Hague Conference did something. We went into archival research as to the work that the HCCH was or is doing in secure transactions. Now, as you know, we are a small secretariat and the resources are limited. And 20 years ago, a working document was written by the Permanent Bureau. And it dealt with secure transactions for something that will become, in the end, our securities convention. So we decided instead to not focus on secure transactions. Interestingly, that working document had comments from one intergovernmental organization, and that's UNIDROIT. That was exactly 20 years ago. Now, 10 years ago, of course, there was the tripartite guide on secure transactions, and that was the last time that the Hague Conference actually did any sort of substantive work in the area of secure transaction. So as I said, very late to the party. But something did happen, basically, which I think it was 2 weeks ago. We decided at the Hague Conference that we needed to do something, which was to look at our commercial and financial law instruments and see what had to be updated or reformed as a result of changes and developments, especially in the digital and crypto economies. And so 2 weeks ago, between the 12th and the 16th of September, we ran an online conference that we called Codify to commercial and financial law. We had international, commercial, digital, and financial law. Quite a few people in this room were also with us at that conference. We had, of course, we were very lucky to have the participation of both UNCITRAL and UNIDROIT in that conference, not only to talk about cooperation and coordination, but also in terms of the substantive issues that needed to go forward for the Hague Conference. You see that link there, and basically we have all of the videos, 32 hours of content online on that YouTube channel. If you're interested, of course, please go right ahead and look at those things. Now, what's interesting about Codify, of course, is that what I want to say is that we're building on the work that UNCITRAL and UNIDROIT have been doing. So the Hague Conference has been observing both the work that has been happening here at UNIDROIT and also with what's happening at UNCITRAL. And the wonderful thing always about following Angelo on panels is that he's basically given you the wonderful comprehensive overview, and there's very little else I can add in terms of what Angelo's already put forward. Now, in terms of UNCITRAL, we are going to reinvigorate, let's say, the cooperation and coordination aspects there. The Hague Conference will continue to, of course, observe, but we intend to take a much more active role in various different projects in UNCITRAL. For example, legal taxonomy in relation to the digital economy and the digital work that they're doing there, but also in particular in relation to insolvency. And I want to touch on that just a little later. At UNIDROIT, we are also then focusing on the work undertaken here by the Digital Assets and Private Law Working Group. We've sat and observed quite a lot of what's happening there. There is the one principle, the one lonely principle in the digital assets principles that deal with private international law issues. And the Hague Conference has committed to take that work forward as we look at digital assets in the digital economy. So we will look at applicable law, jurisdiction, recognition and enforcement, choice of law, choice of forum, but building on the UNIDROIT principle, in particular, the one that has to do with private international law issues. So what's interesting, of course, is that the UNIDROIT digital assets principles include guidance on control, linked digital assets, transfers, custodies, and digital assets collateral. And of course, there's also a working group on enforcement, as Angelo just mentioned. And we follow both working groups, and we intend to keep doing that as we develop our own work in the digital space. The interesting thing, of course, then is that the Digital Assets Working Group was tasked with developing private law-related rules rather than regulation. And of course, the subject there is that digital assets could be proprietary. They could have proprietary rights attached to them. Right now, they examine the issue of enforcement in the context of secure transactions, and the draft principles at UNIDROIT also include guidance on linked digital assets, transfers relating to digital assets, custody, secure transactions, where the digital assets are collateral, and also control, as I mentioned earlier. So the interesting thing then for us is this. I'm going to try and move the slide forward. Thank you very much. And this, I must stress that this will be our proposal to our council next year. One of the ideas or the intentions of having that codified conference was to assess what was going to happen with the international commercial, digital, and financial law portfolio at the Hague Conference. At the present moment, we have 3 instruments that we are working on in terms of post-convention services. That's the 1985 Trusts Convention, 2006 Securities Convention, and the 2015 Principles on the Choice of Law in International Commercial Contracts. We are, of course, then looking at these things that have come out of the codified conference. And the idea is to propose to our Council on General Affairs and Policy, that we call them CGAP, in 2023 in March, when they consider, our members consider what our work program will be. And here you will see that there is possible future work in relation to secure transactions and secure transactions reform. The first thing we're going to look at, of course, is the continued cooperation and collaboration with both UNIDROIT and UNCITRAL. Basically working as we have been in terms of observing. Many hundreds of man-hours go into observing the work of both organizations, and we're very proud to have the privilege of being with them here. In UNIDROIT, of course, as I mentioned, we're going to look at further work on private international law and digital assets, building on the principles that have been developed here at UNIDROIT. At UNCITRAL, aside from insolvency, we're also going to hopefully contribute a little more to automated contracting and the data transactions work that's being done at UNCITRAL. Now, as the basis, so that's really just, in that sense, that the floor of the cooperation coordination. There are other things that we want to look at, which, as we develop our preliminary documents to Council, we're hoping to also discuss with our colleagues here at UNIDROIT and also at UNCITRAL to see if there's a possibility for a joint project. Now, the reason for a joint project, of course, is because, as Angelo very beautifully put out, very eloquently put out, the differentiation between the mandates is not easy, especially when there are areas of law which are adjacent to each other. And when we're talking about, for example, here, the harmonization of private law, or at the Hague Conference, the progressive unification of private international law, it's very difficult to split the two and say that one has a clean mandate and a clean scope that does not touch the other. So we're going to hope and see whether in our research on the development in relation to the desirability and feasibility of future normative work, we can propose joint projects, which we hope that our friends at UNIDROIT and UNCITRAL will consider working with us on. Now, in terms of the possible future work, there are 4 big categories. The first one has to do, of course, with DLT, distributed ledger technologies, and intermediation or disintermediation. And there, it's a bit of a lonely piece of work there, but we want to look at the existing HCCH Securities Convention. It has only 3 contracting parties at the moment. And we had a conference to find out why we're not getting more. One of the conclusions of that conference that we had 2 weeks ago was, aside from whether we have more contracting parties, whether we should look at this convention and attach normative work to it that could be, for example, a standalone protocol, which would work for the crypto or digital economies. Now, we're very careful not to focus on DLT as a technology because our instruments must be technology neutral and technology agnostic. And for that reason, we're not going to focus on a specific technology, but we want to look at the applications of that. Now, we're not going to, of course, reform things for the sake of reform and for the sake of normative work. So we're going to see whether any adjacent work needs to be done for the Securities Convention to perhaps review or update it, or even have perhaps interpretive guides as to how this convention can be used in the digital space. One of the other things we're going to look at is characterization issues. This has already been addressed by the Digital Assets Working Group here at UNIDROIT. Matter of basically how to characterize certain kinds of assets. Of course, the idea is that the continuing work does look at ideas for study in relation to the legal characterization of parties, security interests, and collateral assets using tools which are available in the blockchain, so wallets, tokens, smart contract execution, and decentralized autonomous organizations, or DAOs. Now, these raise questions of whether self-executing code and diffusely held intangible assets, which are managed and held by pseudonymous parties, can transpose to match the typical practices or requirements or legal frameworks of secure transactions. So that's one thing that we are going to start looking into. The third cluster that we were looking into our DAOs, basically. There we want to start with our Trusts Convention. In 1985, a convention was concluded under the auspices of the Hague Conference, which is the 1985 HCCH Trust Convention. And a potential question for study here would be the legal characterization of DAOs and the underlying smart contracts that govern its operation, and whether such globally recognized legal characterization provides legal certainty as to the operation and the obligations and duties on its participants. The most fundamental question that we want to answer there is how to characterize the assets held by a DAO, perhaps in a trust, and what that impact that might have on areas such as Islamic financing. So there might be something to do as well in relation to secured transactions. Now, on the matter of trust, of course, we continue post-convention services. And one of the things that came out of the conference was the question of clarifying what was Article 2 of that convention. Basically, what does it mean when we say institutions analogous to trusts? And whether that has any impact on secure transactions reform as well, in relation to the general understanding of secure transactions in the context of trust as a solution to matters arising from digital finance and embedded finance. And one last thing that we're going to look at is something called soul-bound tokens. As you are probably very well aware, Vitalik Buterin very recently published a paper on that. And soul-bound tokens, of course, are publicly visible, non-transferable tokens, which represent affiliations, memberships, and credentials, essentially reputational tokens that you find on the blockchain. Now, the introduction of such tokens is poised to be quite a significant change, we believe, because up until now, the types of digital assets that we are concerned with are largely things that are bought and sold between users. So they're kind of pseudo-currencies, and the tokens are attached to other items of value, whether on-chain or off-chain. But soul-bound tokens give a way for developers to demonstrate identity, reputation, and affiliation. And those three things allow us to address the issue in relation to pseudonymity. So we want to look at that in relation to applicable law, in relation to recognition and enforcement, and how soul-bound tokens, if used in the context of secure transactions, can impact that space. So the idea, of course, is to give the developers a way to demonstrate these things to other persons or organizations with a digital marker that isn't a tradable asset. Now, Buterin and his co-authors propose an application of soul-bound tokens to help model traditional financial and social arrangements such as landing, collateral, and property rights. And for example, a soul-bound token can be issued by a lender and placed in the wallet of a borrower as a type of virtual lien, indicating that the debt obligation exists and can be removed upon fulfillment of that debt. So one of the projects that we are hoping to perhaps do a bit more research into if we get the mandate next year is one on secure transactions in the blockchain space, which would follow the developments in relation to soul-bound tokens, which can be used to represent and model the fundamental features of secure transactions, such as collateral, debt, creditworthiness, and third-party obligation in a manner that cannot be solely performed by smart contract arrangements. As I mentioned, all of this would basically build on the work that's being done here at UNIDROIT, as well as the work that's being done in UNCITRAL. And we're going to perhaps drop this in quite bluntly and brutally on our friends here at UNIDROIT and UNCITRAL and ask whether there is some joint work that can be done there. While I have the floor, I will abuse it and tell you about the coordination platforms that we do have at the HCCH. I'm aware that you do have a platform here to coordinate the information that's available in relation to secure transactions reform. And I wanted to maybe talk about the social aspect that we hope can also be built into this platform. So as I understand it right now, this platform is a wonderful online information network of networks where there's a map and you put your cursor over it and you find all this information about secure transactions reform that would be interesting to stakeholders. Now, what we found at the Hague conference is we do a lot of coordination of different levels, and the social aspect of being able to ask a question and connect people in the network has been extremely invaluable for us. I'd like to talk about two platforms, just as an idea, perhaps, as you go forward with this platform. The first one is the International Hague Network of Judges, which is a secure platform and password protected. And the second one is on our electronic apostille program, the EAPP, which is on a Microsoft Teams platform and by invitation only. So quite quickly, this is the Hague Network of Judges. Right now, it's a network of about 149 judges from 88 countries at last count, 88 jurisdictions, focusing entirely on family law matters only. We are hoping to extend this network to judges in the civil and commercial law spaces so that we can connect liaison judges between jurisdictions and they can give advice or counsel to each other through something that we call direct judicial communications. Now, of course, there are some sensitivities in relation to judges speaking to each other. The idea isn't that they exchange information about the live case before them, but simply that they talk about the abstract ideas of what's happening in their jurisdiction so that they have ideas about applicable law, recognition, and enforcement issues when the judgment has been given and has a cross-border implication. This is on our website. And when you go there, it basically goes to a splash page where you have to enter an email address and a password. So this thing is actually secured because our judges all have their information on there. Now, what's interesting about this is it's a bit like a Slack channel for judges. And it allows this direct form of communications in a secured manner, which perhaps would also be something interesting for this platform. The second thing is the EAPP Microsoft Teams platform, which is a coordination chat. Forgive me, this is actually a screenshot of my own computer. What we have done is basically connected the competent authorities of the Hague Apostille Convention. And there on this platform, there is a coordination chat. So where there's electronic apostille updates or where there is some question about electronic registries, they go up on this coordination chat. There are various different channels. As you can see, we have one for the e-apostille, one for the e-register, and people can put up their ideas on there, as well as file sharing. So we can put up what an electronic apostille looks like, the reforms that's happening per apostille. And this might be something that might be interesting then for this group to also consider. I will stop there, of course, and thank you very much for your attention and also for inviting the Hague Conference on Private International Law. As always, it's a privilege to be here, and we're very grateful to our sister organizations, in particular the host of this year, UNIDROIT. Thank you.
Thank you very much, Jerry. Your excellent intervention proves that we were right to insist on The Hague being present in this conference, perhaps insisting too much, but it worked in the end. Many of the ideas and the examples that you've shared with us really enriched the discussion. For example, we're not yet there with the platform, but we are moving towards it. One of the things, for example, that we would need to discuss is which information is publicly available. That I would think, might be of interest to someone who wants to know what the law is like and to lower transaction costs in terms of investment. But other part of the information might be restricted to real users or say organization, institutional users of the platform, such as ongoing projects and so on. So this is something we'll need to discuss. I will seize the opportunity now. We're still well within time. Instead of bore you very at length with the current work, I will bore you a bit, but I will take a few minutes to lay out a number of concepts which many of you are, if not all, are already quite acquainted with, but which should inform the discussion and the panels during today and tomorrow. I think the magic word we need to use and we need to turn upside down and stretch and look from every possible perspective is coordination. Coordination is the magic word, and coordination turns up in most of the activities, or should turn up and be very much present in the activities that transnational law organizations have in their competences. So if you allow me, I first make brief reference to coordination ex ante, meaning in the process of setting the standards, standard setting coordination, to speak a little bit then after exposed or implementation of those standards. For the first part, coordination is needed, and here, those that would be affected have not always done a great job, is when a decision is to be made to start work, and countries haven't quite coordinated when they liaise with the different intergovernmental organizations to make the decision. First, to propose a given topic, and then to make a decision about it. So if countries did coordinate a little bit more, some of these small and easily resolvable frictions that sometimes happen between transnational organizations will be avoided, because after all, we serve those countries, all of us, and that's precisely what we do. We have many common constituents, and therefore it's up to those constituents to organize themselves in a way. So sometimes in some countries, it might be as silly as having one organization assigned to the Ministry of Foreign Affairs and a different one to the Ministry of Justice, and they just don't coordinate. But those of us and you who've done implementation reform, they know how little some ministries talk to one another, and so it's just a difficult thing to solve. Nevertheless, it's, I think, important that we raise this issue, because this is a first level of coordination which is much necessary, much needed. A second level of coordination, always in the standard setting activity, would be the coordination needed when a decision is made by the secretariats of the transnational law organizations. And I would be here talking about the drafting. And we do, I think, a very good job in that sense. There are other transnational organizations. I'm just here talking here of the three sisters. We invite each other, we participate in each other's groups. Of course, it has and it bears its costs in the secretariats, but this is something for discussion as well. But what's important is that this interaction exists, and it's well streamlined and done in a way in which it minimizes the costs for the other organization. That is the key. Of course, in my opinion, this works in a streamlined and low-cost manner to the extent that there is trust between the different secretariats. And I think, at least for the three organizations here present, there is. I at least speak for myself, and UNIDROIT, of course. Another level of coordination, which is interesting, is between standard setting bodies and what you will allow me to call hybrid standard setters. That would be, and I mean, of course, no negative implication with the use of hybrid, because these organizations, for example, the World Bank, would be one which has its own, or the EBRD, which has its own standards, and it also has standards which are derived directly from the standard setting organizations. So to the extent that institutions that normally would use transnational law to implement their mandate in a country, but they are at the same time acting as if their own document is a standard, coordination will be needed with transnational law organizations. So this is a two-tiered type of coordination, which is much necessary. I would think in practice it also works pretty well, as is proven by how many of these implementing organizations are present in the room and participating actively in this conference since the very beginning. Then we move to exposed coordination. Exposed coordination would be when the moment comes to translate standards into domestic law. And here, of course, we could mention four different actors. The main actor normally, at least concerning developing and middle-income countries, would be the World Bank or other transnational law, international financial institutions acting regionally. This actor needs to coordinate also in its implementation activities with national development agencies. And here, the coordination is not always good. In my previous life, I've suffered from this, being in a country and working for even years, when a national development organization was financing exactly the same type of legal reform work in the same country in parallel with you, we're not talking to each other. It's not like we were saying very different things, but some of them were different. And that was just money squandering, public money squandering, and a shame. So national development organizations should coordinate with IFIs on the ground, then NGOs who are also directly contracted at times by the governments to provide their input, NGOs and private stakeholders who sometimes do. It's not rare for a law firm based in London to be writing a law for a government in Asia. And of course, a law firm in London has no duty to coordinate with us, with the World Bank or with the ADB, but it would be better if it counted on the information necessary to know what's going on, what the standards are, and that there is a legal framework which is, or not, compliant with the way they're looking at things and the way they are advising the government. So this is another level of coordination, which I think is very interesting. And of course, the final level is all those actors, international law organizations, standard setters, together with national legislators, when they do actually reach out to transnational help. So that institutional implementation coordination is much needed. And I firmly believe that this is the area, this exposed part, where not only, but mostly, where the platform that we are trying to build here would be useful. And bearing in mind the needs and the problems that exist in practice is how we should build that platform to the extent that's possible. So much for that. That gives us a lot of room for reflection in the next 36 hours. Concerning UNIDROIT's work, I wanted to for Angelo to take the floor first, because I knew he would make a fantastic summary of the of the joint projects, so I wouldn't have to do it myself. And I thank Angelo again for that, and my apologies for basking on reflected glory. The current work that UNIDROIT is doing in secure transactions is as follows, very briefly. We continue doing our work, and quite intensely, on the Cape Town Convention. Some of it still legislative drafting. We are about to finish the process to complete the legal framework and the institutional framework required to implement the MAC protocol, which is our, I wouldn't say baby anymore, more like a toddler these days, almost 3 years old soon. Who would say? Many of you in this room were in Pretoria, and because of COVID, we have not been able to see our child grow for 2 years. So it's gone from 1 to 3, and that wasn't good. We're about to finish that. There should be appointment of a registrar actually within a couple of months, and the regulations and the legal infrastructure is almost ready. The rail protocol is about to come to force. Therefore, the regulations are being updated, and that's mostly the work that we can report to this meeting on that front. And I would like to highlight something that many of you probably already guess, if you don't know, which is the amount of work that us as depository and as parents of the creature, in a way, have been having to do, in part through the Cape Town Convention academic project, to bolster and support the aircraft protocol in a moment in which, due to COVID, and now in part to the existing armed conflict, was put to the test to a level that was unimaginable before. Therefore, it has been quite complicated. Obviously, it is not for a transnational law organization to make interpretation of its own statutes, but of its own treaties. But it is for the organization to try to do whatever is necessary within its mandates to make sure that the treaty is respected to the extent possible. The ongoing work, unfinished yet, much of it Angelo has referred to, the model loan factoring, which I think is very good work. It's now in this consultation of a draft. And we are already receiving very interesting feedback. Here we've had very strong coordination with UNCITRAL in the years of drafting. And not only that, many of the members of the working group were experts that drafted the model law on secure transactions and even the receivables convention. So the coordination, it's from the root, model law warehouse receipts. Angelo has already mentioned the more difficult parts of it. And this is still work in progress. We will do the best we can to send to Vienna a as finalized instrument. I don't like the word product for what we do, instrument as possible. But this is a hard cookie. It's a difficult one to deal with because it really goes to the core of the differences between more traditional civil law systems and common law systems. Or at least American system, if you will indulge me there. Some sort of balance needs to be achieved, and that's not an easy, because this is precisely an area where both systems, being fundamentally different, work well, both of them. So there's no clear. No one can say this is modern, this is old, this is no, because in this case, the legal infrastructure is good in both cases. So, we need to be able to come up with a solution for that. Otherwise, UNCITRAL is going to have to do a lot of discussions at the working group level, and that wouldn't be a good idea in terms of resources and coordination either. So enough for that. Digital assets. Angelo has already identified some of the elements where coordination is necessary. The development of our working group and the work of the working group, because of its components, because of the number of observers, and because of the people and the institutions that actually do deal with digital assets still, or at least the ones that we were able to bring to the table, and we really wanted to bring as many as possible. I should say the constituency of the working group, it's so large, which it looks more like a diplomatic conference than like a working group every time we have one. Above 60 intersessional meetings have been held, and to that, we add a parallel structure of a steering committee where we get input from more than 30 governments, sorry. So the amount of input is very, very high. There is not always discrepancy, but it's true that two actors have been very active in the work. One of them is the Uniform Law Commission and its experts. Another one is the Law Commission of England and Wales, both of them, who in these matters, and in particular, the part which Angelo referred to, have relatively similar approaches. And untangling and discussing with experts where there is a quite an unequivocal direction of a technical item is difficult, because you need to make sure that you present an alternative to the proposal that's being put on the table, and it's not easy to do. So anyway, we keep working on that, and we hope that we will be able to fine-tune the end result to the satisfaction of group members and experts, and in a manner which is respectful with the standards that we defend. Enforcement. This is not a new project. This is an old project. It's been in UNIDROIT's work program for many years, and led very ably by Anna here with us. And of course, enforcement is a general project. It's about enforcement. It's not about secure transactions, but it does have, of course, a part on enforcement of secure transactions. And the work here is, as Jerry said before, very kindly about PIL and digital assets, is being built on what was there before. So the enforcement section is a subgroup, starts from where the model law, not the model law, the legislative guide left it off in terms of secure transactions. So there is a lot of attention paid to that. And a good testimony to that is that the leading member of that subgroup is Neil Cohen. So not exactly suspicious of not knowing and not respecting the previous work done by UNCITRAL. So it's He's a guardian of the faith. I can testify to that. Then I think that's pretty much what I could present to you as the current work on secure transactions. On the future, I can't tell for the time being, so we'll see. I think this is enough. We still have 15 minutes for discussion with the floor. So I'd like to know if there are any questions from any of you in Rome or abroad. The floor is open. Marek, talk to the mic.
Thank you, and thanks everyone for excellent interventions and presentations. I have a couple of comments and observations, and as well as some questions. And let me start out with what you call hybrid standard setters, because we have seen a lot of hybrid standard setters in factoring. We have all kinds of model laws on factoring produced by those who don't possess any standard setting powers. And in the digital space, everyone calls himself a standard setter anyway. So there are.
You should have seen Jenny Clift look at Vijay Tata when he said that the World Bank was a standard setter.
So, but some of them actually have some legitimacy, like the European Law Institute and its principles on security rights in digital assets. And as you know, they publish those principles, which are to a large extent inconsistent with the principles that are being developed by UNIDROIT, as well as concerning the applicable law, where the applicable law under the ELI principle is the law of the location of the grantor, wherever that person might be located, which is not the criterion under the UNIDROIT principles. So it's not to bother everyone with technicalities, but rather my question is like, how do you coordinate these kinds of emerging conflicts among the so-called standards with these hybrid entities that publish these standards? The second observation concerns the commissions that participate in this project, the UK Law Commission and UCC, the UCC bodies and Uniform Law Commission from the US. And that also relates to the point that Angelo raised in his remarks, which is coordination among the different types of statutes that govern digital assets. Because indeed, as he pointed out, we have digital assets in the form of warehouse receipts, digital assets in the form of cryptocurrencies and different kinds of assets. But they may be based on the singular notion of control. However, the rights and duties of transferees might be completely different. Whatever you acquire by way of a negotiation may be different of a warehouse receipt than by way of negotiating some kind of a cryptocurrency. So I agree with him. This is not a question. I agree with him that more differentiation among these different types of digital assets might be needed, including within our UNIDROIT project, as that purports to cover all kinds of digital assets. But like in UCC Article 12, we have exclusions from Article 12 that cover electronic warehouse receipts under Article 7. And then final observation concerns Jerry's new project, potential new project on characterization. I'd like to learn more about it. But I think it's very useful because in this space, we have all kinds of transactions that look like secure transactions, but they're not in fact secure transactions. So it very well connects to the work that the organizations have been doing in terms of first enabling the parties to determine what national law applies, and then within the national law, what specific commercial law may apply, such as we had with true leases, financial leases, secure transactions. So this seems to me like a nice complement to UNIDROIT's general work, because some of these maker DAOs might not be or might be secure transactions. So congratulations on that.
Thank you, Marek. Before I give the floor to Spears, and if he will indulge me, I think not to lose the more technical point that you may reference to in response to some of Angelo's remarks concerning digital assets and control. I saw, and I just knew she would, Luis Gallifrey asking for the floor. Luis, the floor is yours.
Sorry, I wasn't going to intervene. Oh, yeah. Can you hear me? Somebody? Yes?
Yes, we can hear you.
I wasn't going to intervene, but I thought I would just on one point. the concept of a digital asset within the digital assets project is merely the controllable electronic record. That digital asset might be linked to something else. So anything that is a controllable electronic record that is linked to anything else, including an intangible right, is a digital asset plus something else. So we do not say that there are different types of digital assets. We say there is one type of digital assets as we define them, but there are lots of things to which a digital asset may be linked, and the link is a matter of other law. So when we're thinking about warehouse receipts or documentary intangibles or anything like that, that is the only thing that would fall within our project is the actually electronic record. And the fact it's linked to something else, we say is not anything we're doing. So if you think of a negotiable instrument, it's a right against, or claim, or whatever you call it, wherever you happen to be in the world. It's a claim against somebody, and it's linked to a piece of paper. We in the Digital Assets Project are interested in the pieces of paper, and that's all. The rest of that link is something else. And so, I mean, there may be overlap, but the overlap is quite limited. And we're only talking about the law of the digital asset. We're talking about basically the law of transferring the proprietary rights in the piece of paper, which may not be in itself terribly important. But what we say is that if somebody purports to link that piece of paper or that digital asset to another right, then that is not something that we are our principles refer to. That is a matter of national property law. So I think that might narrow down any kind of overlap or any kind of sort of coordination problem, because it is actually quite narrow. I mean, there are some digital assets that aren't linked, which some people call cryptocurrencies, but there are also many things, including digital, what's called crypto securities and things that otherwise would be negotiable instruments or documentary intangibles. And we're only interested in the electronic or controllable electronic record bit of it. We're not interested in the link to anything else. Thank you.
Thanks, Luis. Spiros, is your intervention on the digital asset point? If not, I'll give it to Angelo and I'll get back to you. Angelo, the floor is yours on this. Let's not make this a technical discussion. This is our coordination, so this serves an example of a type of discussion, but let's not go much deeper into this. Yeah.
No, Ignacio, I have no intention of making this into a technical discussion. I'm simply saying I fully appreciate that, for example, as regards the so-called endogenous digital assets, those that are unrelated to some true asset of the real economy outside an electronic negotiation environment, that there is a need for looking into the law and saying, what do we have there? Does it apply? Does it not? And probably it's more than welcome that we see what does these categories mean in respect of what kind of proprietary interest you have in them or not, etc. But when you say that that work could also encompass exogenous assets, that is something that simply represents a right on something that exists outside. For example, the electronic warehouse receipts, for which there is an absolutely well-established paper-based equivalent. I wonder whether then the substantive law provisions that one will be developing for dealing with the purely digital endogenous assets would make sense also in that environment. It may not lead to unexpected conflict with existing law. I personally see Articles 12 and 7 of the UCC as fundamentally inconsistent in the notion of control that they're employing, and that's a technical discussion. I'll simply like to stress that I am confident that the wide assembly of brilliant minds that you have put together for this project will find a solution for that. And then I would simply like to, since I have the floor, to pick up on one comment that Marek made, and because I don't intend to be asking for the floor again, and that is how we relate to this so-called hybrid institution or hybrid standard setters and others that develop and so-called legal models and standards. Of course, we don't have a monopoly of ideas, right? We can't prohibit anyone from producing a document, calling it a model law. And in some areas and some organizations have been successful with that. What we can do is try to involve them as much as we can in our work as observers, and then to engage them and let them to also to buy our products. And I think our experience with the World Bank has at the end become a very successful, and through the fact that they have been participating in the formulation of these standards as well from the beginning. And we try to do the same also with others like ELI and the American Law Institute as well. And then when it comes to the implementation, what then also people have increasingly realized, also some of the even bilateral development agencies, that there are many instances in which the recipients would place greater trust on something that comes out of a neutral intergovernmental process rather than on purely regional or domestic quote-unquote standard that is being promoted to them by an NGO or a private law firm. But again, we cannot dictate the way bilateral development agencies operate. You can regret sometimes that there missed the opportunity of promoting further government-sponsored uniform standards. Thank you.
Thank you, Angelo. Spiros?
Thank you very much, Ignacio. A couple of points on coordination in the preparation of legislative standards and in the implementation of those standards. And then one remark on the contribution of the Hague Conference and the importance of private and national law. First, on the preparation of standards, the three organizations have set already a high standard, which is reflected in their joint publication. The amount of coordination that is evidenced in this joint publication is impressive. One can see there that they have coordinated very closely, very harmoniously in the preparation of those standards. If we can maintain that standard, that would be a success. Maintain that standard by following that example, and perhaps even at some point of time seeing an updated version of some kind of joint publication, even if it's not joint, but a publication that will show how these standards relate to each other and provide that information to states. My second remark is on the implementation of the coordination in the implementation of international legislative standards. Here, of course, much more needs to be done. There has not been coordination or sufficient coordination. There are different agendas, different budgets, different mentalities. I can even testify to the fact that insolvency law experts and secure transactions experts from one and the same country, many countries, discussed relevant issues between the interrelated between secure transaction and solvency for the first time in a joint working group session of UNCITRAL. They will not talk to each other, and the government departments will not talk to each other or will not communicate easily with each other. That, of course, goes back to more than 2 decades, but that was the situation then. And my third and last point is this. I'm glad to see the Hague Conference participate in this conference. It has a right, and the right is based not only on the Securities Convention, but on the amount of work done on all secure transactions texts, to the extent they include private and national law provisions. The private and national law provisions in all UNCITRAL secure transactions texts have been prepared with the coordination and assistance of the Hague Conference. And that is why the Hague Conference was included in the joint publication. So I'm glad to see the Hague Conference back into an area in which it has provided so much work, so much guidance, And private and national law, at least I believe in it, has future, even if substantive law is unified to a large extent. And secure transactions is an area which has made that clear, because even if we have the same two secure transactions law in two countries, we will still need an applicable law rule to know in which registry, national registry, a secured creditor should register. And that's only one of many examples for the importance and the need for private and national law provisions and for the coordination and cooperation with the Hague Conference. Thank you very much.
Thank you, Spiros. Sometimes one needs to convince people who have rights to exercise them. So let's do this. I'm going to give Jerry the floor to comment on whatever has been said before, after which I have, for a long time, Magda Rasinska, who wanted the floor, then Anna, and then Thomas. We are already 3 minutes beyond time, so please be brief in your remarks. Jerry.
Thank you. I will be brief. First, thank you to Marek and to Spiros for those very kind remarks. First, on the matter of the hybrid organizations, as Ignacio puts it, we do work a lot with them. And I think that's where we need also our members. So not just the people in the room, but really the member states of the organization to follow the work closely enough that they come forward with their ideas. Because, you can drag a horse to water. But basically we need to get the people there in the room. So we can, of course, we do talk to the ELI and the American Law Institute and all that. But we do need them to step forward and tell us when they have work. We cannot, given the size of the Secretariat and resources that we have, follow every single jurisdiction. So there, I think that's really something that we hope our members will do. At the Hague Conference, what we're also doing is to try and increase the membership. So as you all well know, it started off as a very European, Eurocentric type organization. And now we're trying to get more. So we have made inroads in North and South America, Latin America, and the Caribbean. We are trying very hard with the Association of Southeast Asian Nations. We will have a huge initiative to try and move Africa, because these are the continents where, especially for things like this, secure transactions, access to financing, embedded finance, this is where we actually need all of these members to get involved and to give us their input. We've also benefited from the contribution of the European Commission, who sits as a member at the Hague Conference. And so they coordinate and they come with a 26-member coordination type statement. That really helps us. We're hoping that other regional economic integration organizations like ASEAN and OHADA can also do something like that. That way we can get much more inclusiveness and diversity in our work. So I think that's the thing about hybrid. We do need people to get involved. Now, my second point on that actually is the matter of the timetabling. The three sister organizations have their governing councils, or our Council on General Affairs and Policy and the Commission meetings at different times in the year for different work plan periods. And that basically something that we need to take into serious consideration when we have joint project proposals or so on. We need to get those things through. We need a mandate. So those projects characterization, for example, Marek pointed out, it's very close to my heart. I need to get a mandate for that from our council. So, we really need to work on that. Now, to move quickly with Spiros's intervention, the implementation, we do something at a Hague Conference, which I think is a good idea, which is our special commission meetings. So every 5 to 7 years, we have a special meeting of the special commission for each of our conventions. We just haven't had one for our commercial and financial law instruments because of the low number of states parties that have joined that convention. That is a terrible pity. So we try to address that with the conference that was organized 2 weeks ago, but that's a conference and it's not a special commission. When we have a special commission, we get our competent authorities together, we get our national organs together, and we sit them down in a room and we talk implementation. Because as very correctly pointed out, sometimes you have judges in the same jurisdiction holding completely different holdings on exactly the same matter. We found that for various different conventions, and we found that the special commission meetings that then come up with mandates for guides to good practice and interpretive guides, that really helps. So perhaps that's something that we need to look at going forward. And it might be something as a joint proposal, and I'm sorry to drop it on our sisters here, to actually have also a coordinated type of special commission in relation to this sort of of projects and so on. But what we need, of course, is the mandate. And what we need is our members to get together, follow the work of the organizations, and make sure that there is some sort of proper coordination there. So I think those are the three main points. I think the coordination is very important. We are trying our very best. It's good to be back. I think the Hague conference in the room, it's a matter of the resourcing and getting the mandate. As I said, many hundreds of man hours go into this observation and to the interpretive guides and in all the legislative guides and so on. We need a mandate for that because otherwise it doesn't reflect in the work of the PB. So it's hard for us to justify all of these hours. Therefore, our members need to step forward and say, yes, we ought to do some more like this. We need to have some more coordination. I thank you for the floor.
Thank you, Jerry. I think one point which is interesting for discussion is whether in a transnational law level, it's better to have enhanced coordination, meaning 26 countries come with one voice ex ante, therefore depriving the rest of the discussion from the participation of 26 experts, or the other way around. So this is something I've always wondered, whether it was actually good for the decision-making process of UNCITRAL or The Hague that a decision by the European Union preempts any possible discussion by its member states. It's an interesting discussion that we can have, not now. Leave it there for time whenever we can. So we have three interventions. Please keep it short. Magda Rasinska, you there? There you go, please.
Hi, thanks very much. I'm a newcomer to this conference, Hague conference, and I do have a question for Jerry, actually. I was listening with interest to the areas outlined for the future work, and if mandate is given, I wondered whether there is a sense of the type of project that might end up being the end game. So is the idea to produce a convention or something else? And if it's not determined yet, what might be the factors you might like to might influence that decision? So is it a matter of coordination or something else, or is the idea just to produce a convention in relation to all those areas?
Thank you. I think I'll collect all three questions and then Anna. No? Thomas.
Thank you. Just briefly, a point raised by Gérardine's presentation on one of the possible future lines of work at the Hague Conference on the Hague Securities Convention. It's the low number of ratifications, also developments like DLT and disintermediation, which might need some reconsideration of that convention. I just want to point out that there is this UNIDROIT legislative guide on intermediated securities where the Hague Convention is discussed. So if there are any changes that might impact the legislative guide, and there's another path of work that impacts on the legislative guide, and that is the work in the digital assets group. Because when the legislative guide was written, there was mention in the legislative guide of nascent technologies, but there was no way of writing anything sensible about it because they were still so young. But now that they've grown, there would be space also there to develop the legislative guide. So there are two future tracks that may impact on the legislative guide as it currently stands. So thank you for that.
Thank you. I think, Jerry, you will close the session, please.
I'd hope not for that privilege. It's kind of scary to be back and then suddenly be bombarded by questions, but thank you. Briefly, as the Secretary General has requested it to Magda, we're not going to create treaties for the sake of creating treaties. I think what we do first is to look at what we have existing, look at those conventions and see whether they are still applicable, whether any sort of interpretive guide or, for example, the trust conventions, whether the analogous institutions can also include DAOs, for example. That's what we're going to do first. As a next step, we're going to look at what's already being done with UNCITRAL and UNIDROIT. We're not going to repeat work simply because that'd be a terrible waste of resources and quite disrespectful, honestly, to our sister organizations. We'll also then look at the other work that's being carried out that we're aware of before we see whether there is desirability and feasibility for a normative instrument. Now, that's the core business of what my organization does, but normative work does not necessarily have to lead to a new convention. Normative work also is future studies into desirability and feasibility, into protocols, into guides, and so on. So I think hopefully that answers the question. Thomas, thank you for those 2 points. We are aware that some of this will impact on the legislative guides. I think what's important as well is that even though the technologies are much more mature today than they were at the point of time of publication, that the work needs to be quite technology neutral and agnostic. So for that reason, we're not going to focus specifically on DLT or those kind of technologies, but more the functions and the applications coming out from that, and see whether there is a need for the update. And if there is a need, of course, we will speak with our sisters and try and fix that problem. So, but thank you very much for those 2. I hope I was brief enough, Ignacio. Thank you.
Very good. I always, final reflection, this thing about technology neutral, I always find it very difficult. It's like saying, well, we have an aircraft protocol and a maritime protocol, but let's imagine that, sea and air are the same. It's very easy to say, very difficult to achieve. And we've been seeing that in our instruments. Anyway, please join me in thanking Angelo and Jerry for their excellent presentations, and to all of you for your participation. Thank you.